Justice Sri Krishna, can you all hear me?
Yeah, we can hear you.
Yeah. Dignitaries from all over the world, ladies and gentlemen, I have been in a state of bliss for the last 2.5 years since I retired from the Supreme Court. Justice Sri Krishna will tell you that the imprisonment is not simple, it is rigorous. And once we are out of that great institution, that bliss rarely gets disturbed, except when sometimes I'm asked to give speeches like this, because it takes you back to your good old or bad old days when you were so flooded with work that there was very little else that you could do. In order to speak to you today, I have actually gone through a large number of judgments in various jurisdictions, all from the last year or 2 years, and ultimately decided to focus on 2 judgments, both of the Singapore Court of Appeal. One of which is the celebrated Republic of India versus Deutsche Telekom judgment, and the other, which is Anupam Mittal versus Westbridge Ventures. And why I have done this is because they raise certain issues with the New York Convention with multiple views, and I thought that I would give you my view on each of the subjects that was discussed. In the first judgment, the vexed issue before the court was whether an enforcing or an enforcement court is bound by what is held in the seat court in a situation where an award is upheld. Because situations where the award is upheld and where it is set aside do somehow lead to different results in different jurisdictions. And we'll have to address that. The facts of this case were that we had a company that was set up in India called Devas, and it was set up by some Americans who had bought spectrum, a whole lot of satellite spectrum from the government of India, its arm being Antrix. Now, this was done in 2005, but in 2011, the government decided to get out of this agreement and repudiated it. There were many like Deutsche Telekom who had actually invested in Devas as a result of this agreement. And they had done so in pursuance of a bilateral treaty between Germany and India. Now, the moment this repudiation took place, Deutsche Telekom went to arbitration in Switzerland saying that what you have done is you have breached this bilateral treaty and I have suffered damage. The Swiss arbitrators first held by an interim award that they had jurisdiction, that sovereign immunity that was claimed by India was turned down. And finally, they also turned down a large number of pleas based on fraud. Because in India, there were 2 proceedings between Devas and Antrix. One proceeding was a winding up proceeding, which actually ended up winding up Devas, in which certain observations of fraud were made. And the other was an ICC arbitration, which was an award in favor of Devas, but ultimately set aside by the Indian courts, also on the ground of a fraud having been played on the government of India. Now, the plea was that Deutsche Telekom had invested knowing about this fraud, which was turned down by the Swiss courts. When enforcement proceedings were started in Singapore, the first question that was raised by the court was as to whether something like issue estoppel or primacy to be given to the seat court could arise in such situations. And mind you, the situation here was a situation not of setting aside, but of upholding the award. And they ultimately found, yes, it is grounded in the New York Convention. If we have a brief recap of Article 5 of the New York Convention at this stage, it will be useful. Because Article 5 essentially gives you grounds to resist enforcement and says these are the only grounds. It's important that you underline the word only. And also that you underline the word may. A lot turns on it. Does may have a discretion? Does it not have a discretion? And the grounds essentially relate to either jurisdictional or natural justice issues. They do not relate to a review on merits. It's the fifth ground with which we are directly concerned here. And the fifth ground says that where an award has been set aside in the country in which it was made or suspended or not yet become binding, even then, naturally, recognition and enforcement ought to be refused. Now, the moment it says this, the pro-enforcement bias, if I may call it that, of the New York Convention gives way to two other important principles: party autonomy and the other principle of committee. Because the moment another court's jurisdiction, which, by the way, the parties have chosen, because the moment they choose seat, they've chosen the entire challenge procedure as well before those courts. The moment they do that and the award is set aside, then out goes the pro-enforcement bias and in comes in these two principles, as opposed to the rule of law in the enforcement country principle. Article 6 also then tells us that it is possible to go ahead and enforce an award where somebody is trying to challenge it and the challenge hasn't yet got off the ground. Of course, on payment of, on terms as to security, etc. And Article 7, which is also important, says that nothing in the foregoing will ever come in the way of a person trying to enforce an award if he is given certain additional grounds in the country of enforcement. Now, putting all this together, where does issue estoppel fit in this scheme? Issue estoppel, as a matter of fact, arises directly from committee, because what you are saying by issue estoppel is that if, as a matter of fact, all the parameters of issue estoppel apply, which is that you have a final and binding judgment by a competent court of jurisdiction on the same subject matter between the same parties and not subject to the defenses under 5, then you will go ahead and immediately resist enforcement if it happens to be an award which is set aside. Now, issue estoppel, therefore, could be said to arise from the set-aside clause. It could also be said to apply because of Article 7. Now, Article 7, as I told you, preserves certain rights to persons who wish to enforce. So, if the setting aside court has in fact endorsed the award, and that endorsement is something which is allowed under the law of that land, then, of course, completely, as I told you, different considerations arise. Now, you can also have three situations in which this happens. You can have the situation which arose in Deutsche Telekom, which is that the seat court judgment comes first and issue estoppel is applied by the enforcement court. You can have another situation where there is another enforcement court which has held something, and when the matter goes to yet another enforcement court, the first enforcement court also then is applied qua issue estoppel. You can also have a converse situation in which you can first have, as a matter of fact, the judgment of the enforcement court followed by the judgment of the seat court. And if it's the other way around, does issue estoppel at all apply is one question and one conundrum which arises. Now, so far as the first situation is concerned, which was the situation in Deutsche Telekom, the court had no difficulty in following two UK judgments. The judgment in Minmetals, Germany, which was a judgment of 1999, which said that there is a strong policy which favors the following of what is said by a seat court. And absent exceptional circumstances, you will naturally give effect to what that seat court says. The same was held in a 2020 judgment in Karpatsky, with two interesting refinements. One refinement being that the issue need not be identical, it needs only to be substantially similar. And of course, after the issue is substantially similar, you may apply what is called the Henderson exception. Now, Henderson was an 1847 judgment, and it said that it's an abuse of process to allow somebody to raise something afresh in the second court, which wasn't raised in the first instance. Instances of the second situation are in Die Human, which again is a judgment of the UK court, which followed an Austrian enforcement court's judgment in order to have issue estoppel apply so far as a certain award given in Czechoslovakia was concerned, saying that the award had not yet become final. So it did not apply its own mind. It ultimately said this has already been held by Austria. Parties are stopped now from raising this here, of course, subject to exceptional circumstances. The third interesting situation is the situation in Dallas case versus the government of Pakistan, where the reverse occurred. Enforcement occurred first in the UK. And the simple question was as to whether the government of Pakistan was in fact a party to the arbitration agreement, because some Hajj committee was in fact the nominated party. And the question was as to whether that Hajj committee was an arm of government or wasn't. Now, the English courts held it wasn't, and therefore refused to enforce the award. However, it went to France thereafter, which was the court of the seat. And the court of the seat held the exact opposite and said on the same facts that we are very sorry, as a matter of fact, our French code is extremely limited. Our code has item 1520 in it. Either the award fits the parameters of 1520 or it doesn't, which is really almost an ostrich-like approach, which ignores the court which is supposed to correct the award altogether. Now, apart from issue estoppel being held to apply, the court also went into whether there is something like a prefatory or a preferable jurisdiction insofar as the seat court is concerned. So do you have what is called a primary jurisdiction and a secondary jurisdiction, or do you not? And the court, though it said that we don't really want to get into this, went on to say that yes, it would apply, and the seat court, being the primary court as recognized under Article 5, would really be given primacy over other jurisdictions and therefore would have to be followed. And in doing so, it applied US authorities and Australian authorities. Justice Mance, who concurred with the ultimate finding so far as issue estoppel was concerned, said, I don't think we should venture forward into this primacy principle at all. Issue estoppel is a flexible tool. It's a tool based on justice. Exceptions are also based on justice. And the primacy rule, though it raises only a presumption, is not a rule you can really ground in Article 5, because Article 5 only refers to setting aside, which is not a situation which has occurred here. The situation before us, that is before the Singapore court, was the converse situation where the award had been upheld. And if that is so, how do you accord primacy when 5 does not apply, which speaks of setting aside? When we come to an award which is set aside, we have other complications which arise. Now, you can have, again, 3 types of cases. You can have a case where the grounds are so narrow, as in France, that your grounds are even narrower than the 5 grounds or 4 grounds in Article 5 of the New York Convention. You can have a situation where you have an Indian Act where the grounds are almost repeated verbatim in our section 34 and our section 48. Or you can have jurisdictions like the UK where, for example, you can actually set aside an award on a question of law, which is really a question then that relates to merits. Do different results obtain because of the kind of setting aside laws that each jurisdiction has? Is again a vexed question. France and Belgium have taken the view that they will look only to their own law, and their law being extremely restricted would have most awards pass muster straight away and would ignore almost completely the court that set aside that award. The only time that they would have recourse to the judgment setting aside would be in their felicitous expression used that when the arbitration happens to be an integrated part of that legal system. Now, integrated part again is a very loose expression, probably refers to arbitrations which are either compulsory or arbitrations which emanate from court proceedings, perhaps both, I don't know. But the French system, which is ostrich-like, does not have regard to the setting aside judgment almost completely, except in this one exceptional case. You then have other jurisdictions like the UK, Holland, etc., all of which say that we must enforce the judgment setting aside the award unless it is contrary to the public policy of our country. Now, that public policy again can be expanded or reduced depending on whether they are referring to due process and bias, which are really natural justice grounds, or depending upon whether their public policy, as was held in the US, is that there ought not to be a review on merits at all. Now, you can have a situation where, for example, you have a UK court which holds on a question of law that the award should be set aside. In the United States, the approach would have been that, yes, we would have enforced that award, and we would have, unfortunately, we cannot now enforce any setting aside for the reason that it would be against the public policy of the US to have something set aside only on a ground of law, which is a review on merits, and which we will not therefore get into. So we have various views of opinion so far as setting aside is concerned. Of course, one extreme opinion again is that you can have a situation where a court says, as in Luxembourg, for example, that an award that is set aside has no legal existence at all. Now, that would be plainly incorrect according to me, because if you see the language of Article 5 and Article 6, an award that is suspended is put on the same footing as an award that is set aside. And an award that is suspended certainly has a legal existence. That, coupled with the discretionary may that is used, would show that yes, in most cases, you would certainly enforce the setting aside judgment, but there may be exceptional circumstances in which you would not. I would really, at the end of all this, say that the British approach seems to be the most correct. One, it is grounded in the principles of committee and party autonomy, as I told you. The rule of law of a particular enforcement country should not or could not be able to trump these, because this is the competing area. And of course, if the rule of law is to trump these, then the situation should be so exceptional as to almost say that there is no judgment worthy of the name. There's no judgment, as a matter of fact. Either there is such perverse reasoning as to lead to a conclusion that there is bias in favor of the person who has actually approached the courts there, or some other situation in which you would say that the judgment is not a judgment at all, but almost an administrative decision. So I would really say that it is important not to follow the French approach, not to follow the other extreme, the American approach, because under the American approach, you are not giving effect to party autonomy, where parties have agreed that they will ultimately be subject to the courts of that jurisdiction and the law of that jurisdiction, which includes, for example, a review on, limited review on merits, maybe on a question of law. So Finally, I feel that it is important to go by the median or the thing in between, which is that, yes, of course, the moment the convention says an award that is set aside cannot be given effect to, you must give effect to that. Save and except in these one or two exceptional circumstances, because the pro-enforcement bias now gets turned on its head. And once the award is set aside, we have committee, and as I told you, party autonomy versus the rule of law. So this deals with the first interesting Singaporean. So far as the second is concerned, that also raised very interesting questions. In that case, the appellant was a shareholder of an Indian company. He was an Indian shareholder of an Indian company. And the respondent, Westbridge, was a Mauritian company who invested in this Indian company by purchasing shares. There was a shareholders' agreement between two groups. The appellant had various cousins who he alleged went over to the Westbridge group. But what is important to note is that the shareholders' agreement was an agreement which said that you will have an IPO within 5 years. Now, an IPO is a limited initial public offer. And if you don't have that IPO, Westbridge is at liberty then to walk out. And when it walks out, what it can do is to foist somebody in its place, which foisting has to be accepted by these shareholders. Save and accept if that person happens to be a competitor. So when disputes arose, the appellant was ousted as managing director and alleged that the person that they sought to bring was really a competitor. The first shot was fired in the NCLT here, which is the tribunal which looks into company disputes. And he filed what is called an oppression and mismanagement petition. Now, this really has its genesis in English law. Section 210 of the Companies Act of 1948 in England codified an equity principle, which was that if one shareholder or director behaves harshly in a burdensome manner or wrongly to another, then a company court could give relief. Now, in India, it is settled law that for at least 3 reasons, such disputes cannot be arbitrated. The first reason is that when you file what is called a Section 241 petition before the tribunal, you have to show the tribunal that the company ought to first be wound up. Nobody can decide that a company should be wound up except the company court. Reason 1. Second, but to wind up the company would unfairly prejudice some members, which is why you're not winding it up. And you are giving various very, very wide reliefs which can be given to avert the oppression or mismanagement that is alleged. Also, a threshold limit of 10% is given. Now, you cannot approach the tribunal unless you are a 10% shareholder at least. So, the agreement that was entered into, we had a clause 20. And that clause 20 was a clause which was drafted somehow to get over Indian law. And the clause 20 said that if there are management disputes specifically, first you will undergo a mediation process. If that fails, you will undergo arbitration. But not arbitration in India because that would be prohibited. You will undergo arbitration in Singapore. Now, Singapore was chosen as a neutral venue. Singapore had nothing whatsoever to do with the parties or the transaction. Don't forget, even the foreign party was a Mauritian company. So, in this situation, once the NCLT proceeding had been filed in India, the counterblast was a proceeding by Westbridge in Singapore stating that an anti-suit injunction should be granted immediately. And an ex parte anti-suit injunction was granted from proceeding with the Indian proceeding. The reason being that the appellant, by going to the NCLT, had breached his agreement. Now, in this situation, the appellant counter-fired by going back to the Bombay High Court now and saying that this anti-suit injunction should itself be injuncted, so that we have now 3 proceedings. The first court in Singapore held yes, we grant the anti-suit injunction and gave various reasons for granting it. The Court of Appeal first went into the vexed question as to what exactly would be the law that would apply to the arbitration agreement. Because the law that applied to the contract itself was Indian law. Everything was Indian, short of Singapore being the arbitration seat. And after deliberating on this issue, the court came to the conclusion that yes, following Salar Markia, that you do, if no actual law is indicated by the agreement, which it found, yes, there was no actual law indicated, then you go by what the contract law is, which would have been Indian law. But then you specifically crafted this agreement to get out of Indian law. And therefore it can't be Indian law. So therefore, as a process ultimately of inductive reasoning, it had to be Singapore. Now, I am a little surprised that nobody argued, and therefore you can't really fault the Singapore court. Nobody argued that this kind of dispute is not arbitrable according to Indian law. There is a Mauritian shareholder who has subjected himself to Indian law because he's purchased shares in India. So the fact that the company is a Mauritian company is irrelevant. It's like any other Indian purchasing a share. And that this kind of thing could really be decided as a matter of committee only by the courts in India. Anyway, since this was not argued, and what was argued before the court was what is the correct law that would apply. Unfortunately, appellant only argued that the correct law that would apply to the arbitration agreement is Indian law, instead of saying that the agreement itself is bad and void, led to a result which was probably correct in law, that yes, the Singapore law would apply. Then when it came to the actual anti-suit injunction being granted, Vijay Karya's judgment was cited. Now, Vijay Karya had said that under Section 48 of the Indian Act, if there is something which is contrary to the public policy of this country, as opposed to something which could be waived between the parties, then there is no discretion. The courts enforcing would have no discretion and could not possibly enforce an award which was contrary to the public policy contained in Section 241 of the Companies Act. The Court of Appeal in Singapore said, yes, this appears to be correct. The respondent has not been able to distinguish this judgment. But then goes on to say, however, at this point it is too speculative to say as to whether, finally, this result alone will obtain in India. First. Second, it also goes on to say that the Bombay High Court proceedings have not yielded anything for a period of 1 year. And therefore, it would be very difficult for us to ignore this fact. What was, however, ignored was the fact that there was an NCLT proceeding that was pending, in which all these disputes would be decided, according to Indian. And then another piece of reasoning was that the parties will be able to test their relevance, their strengths and weaknesses. But then the immediate answer would be, yes, but at what cost? And for what purpose? And fourth, res judicata may obtain once the award is given in Singapore. And since it may obtain again, we will grant an anti-suit injunction. Now, res judicata can never obtain for the simple reason that an Indian court, while enforcing, would apply Indian public policy and not Singapore public policy, under which such an agreement may well be valid. The subject matter, therefore, is not the same in law. But given all this, I would still state that the judgment, apart from the reasoning on facts, is otherwise well reasoned in coming to the conclusion that Singapore law would apply. The only problem was the very first important argument that should have been taken was not taken. Having done with these two judgments, I can only end by now saying that in this court also, or in this country also, the courts, by and large, at least at the higher levels, and certainly at the Supreme Court level, do what the Singapore courts did. That is, they look at the convention closely, they reason on the convention closely, they look at other countries' views on the convention, and then arrive at their result in law and on facts. The only problem is the time taken. Now, I have been suggesting for many years, but they don't seem, they've amended the act n number of times, but they don't seem to take seriously the suggestion that the single judge state should be removed altogether. There should be no single judge. When you challenge an award, you go straight to a division bench. And the division bench, again, should be a specialized division bench dealing with these matters, which are then taken up expeditiously and disposed of. Because once this is done, this place will really become a hub for international arbitration. Otherwise, everything else is there. Thank you all very much.